Tēnā koutou katoa, ngā mihi nui kia koutou katoa. It's my pleasure to welcome you to our seminar on the changes to credit laws. We're really sorry that we're not able to do this in person. And we wanted to say thanks for taking the time during these difficult days to spend this hour or so with us, listening to our experts talk about the reformed credit laws. And thanks in advance for understanding any Wi-Fi wobbles or technical glitches. So I'll open with karakia. Whakataka te hau ki te uru, whakataka te hau ki te taonga, kia mā kina kina ki uta, kia mā taratara ki tai. E hi aki ana te atakura, he tio, he huka, he hauhunga, tihei moriora. So we have an interesting couple of hours ahead of us as we discuss the changes to the CCCFA, which, as you know, is the Credit, Contracts and Consumer Finance Act. Today is about helping you to better understand the changes that are happening, but also for us to hear from you about how we can provide better guidance and answer your questions. Today, you'll get the opportunity to hear from our credit leaders, Louise Unger, the General Manager of Credit, John Lyle, our Credit Investigations and Compliance Manager, and you'll hear from our credit experts, investigators and lawyers, who include Mark Atwell, who will talk about responsible lending, Wendy Blennerhassett discussing due diligence, Crystal Uden talking about disclosure, James McIver, who's ready with information about fees and advertising, and Kylie Higgs, our expert on certification. So today is stage one of our information sessions. Next week, you'll receive an invite to some in-depth webinars. They're 45 minutes long, and they're each on 5 different subjects with our experts. We know that these changes are significant and complex. So the follow-up webinars will dive into more detail. And to make these really effective, we'd like to hear from you. We need you to tell us what you want to know about so that we can make sure that you have the information you need. So how do you do that? At the end of this session, when you close the window, you'll be redirected to an anonymous survey. Pop your questions in there. They'll guide the in-depth webinars. Now, before inviting our General Manager of Credit, Louise Unger, to speak to you all, I'll quickly go over some housekeeping. If you have a technical issue, please raise your virtual hand. It's under Reactions on the bottom right of your screen, and we'll see if we can assist in the chat function. Penny is handling our Zoom, and I'll quickly introduce Penny now. Welcome, Penny, and thanks for helping us out.
Kia ora.
So Penny's there if you need any technical assistance. She'll do her very best to help you out. And as I said earlier, if you have any questions during the presentation about the law changes and what they mean for you, please note them down and add them to the survey, which will pop up at the end of this webinar. This feeds into the information we provide in the in-depth webinars in a couple of weeks. But now I'd like to introduce our General Manager of Credit, Louise Unger. Thanks so much, Louise. It's lovely to see you.
Thank you, Sonia. Thank you to all of you as well for coming today. As Sonia mentioned, we're all grateful you can take the time to come and learn about the changes to credit laws, especially in the current lockdown environment where we know how hard it is for many people to work as well as manage family life. As you've heard, I'm Louise Unger and I'm the General Manager of the Credit Branch of the Commerce Commission. I've been in the role for probably almost 5 months now. I was pretty excited to be given this opportunity to lead the Commission's end-to-end accountability for consumer credit, as it provided me with a much wider opportunity to drive what I feel like I've been driving for many years, which is sustainable and effective compliance with the CCCFA, which provides the right outcomes for consumers, but also takes into account the at times challenging aspects for lenders when implementing this legislation. From a personal perspective, I absolutely know firsthand how challenging an implementation program for CCCFA reform can be. In my previous role at BNZ, my colleagues and I were intrinsically involved in BNZ's implementation of the 2015 changes. And like all lenders dealing with that reform, we faced into some really challenging issues and decisions as we navigated our way through entirely new concepts for New Zealand lenders. It's probably fair to say I came out the other end with a few more grey hairs and wrinkles than I had when I went into that project. but it has definitely provided me with first-hand knowledge and understanding of the challenges of new legislation implementation, which I know lenders are currently also grappling with as you navigate the 1 October changes. So today is an opportunity to learn and to hear at a high level about core areas of the law that are changing. You'll have the chance, as Sonia mentioned, to tell us what you want more clarity on and the areas you'd like us to provide more education around through the online survey. And where we can do this, we'll do it through the deep dive online workshops in a few weeks. So today, you'll hear about the changes from law experts on 5 key areas. This is just to reiterate again what Sonia said. So firstly, responsible lending, then due diligence, disclosure, certification, and fees and advertising. However, I'd like to start with something that I know is front of mind for many, and that's our education and enforcement approach. So I'd like to introduce you to John Lyle, our Credit Investigations and Compliance Manager. John?
Kia ora tato, and thank you, Louise. I'm John Lyle, and I'm the Investigations and Compliance Manager, as Louise mentioned, for the Credit Branch of the Commerce Commission. So law changes, as Louise mentioned before, since 2015, and the introduction, for instance, the responsible lending principles, has seen the Commission change from just having a few investigators in the credit area to one where we now have our own branch. And we were actually fortunate to have Louise with all her experience as our General Manager. So I'm talking about our education and enforcement approach to the reform changes. It's helpful to set the context by noting some general observations about the Commission's role and approach more generally to its responsibilities under the CCCF Act. Our priority is always to maximise compliance with the legislation, and therefore also the new changes as efficiently and effectively as we can. The purpose of the Act is to both protect the interests of the consumers and also to promote and facilitate the fair, efficient and transparent credit markets but it's not only for consumers, but also for lenders who are providing services in those markets. So following on from this context, the most efficient and effective thing the Commission can do as a regulator of the consumer credit is to work as closely as we possibly can with lenders to help them comply with the new laws. What this means in practice in relation to our approach to the new laws is a few things. Firstly, we'll have a significant focus on engagement and education in the lead up to the changes and also after the 1 October. We recognise that through implementation, you'll come across issues and that may give rise to some uncertainty or challenges in relation to how lenders interpret or apply the new law, which this also may be areas that we are not currently aware of. So we really welcome your input into some collective discussion of these areas, which might require some clarification from us through Commission guidance. So secondly, while the Commission does not have the legal mandate to offer a form of grace period after the 1 October for compliance with the new laws, our existing enforcement model that's set out in our enforcement response guidelines underpins our focus on and preference for engagement, education and outreach in relation to compliance with the new laws. Our enforcement response, whether we take a low or a high level response, is particularly driven by the factors of harm, conduct, and public interest. On the conduct side, we'll certainly be factoring in lender behaviour and willingness to comply with the new laws and our investigations. This will include, especially in the initial months after the 1 October, whether an approach taken by the lender is, in our view, a genuine mistake or a misinterpretation of the new laws. Thirdly, following on from these other points, if we do see widespread harm from non-compliance with the new laws or a lender's conduct significantly departs from expected behaviour, we won't shy away from taking higher level enforcement action in the appropriate cases. So we'll also consider in some cases whether it's necessary for us to clarify the law through our enforcement approach as well. To give you a quick example of this educative approach and practice, before the previous advertising changes came into effect, we'd heard from stakeholders and consumers that some advertising may require correction once those reforms came into effect. We felt there was an opportunity at that stage to engage earlier with lenders on our concerns, to give them the opportunity to make the changes that would put them in a much better position once the advertising came into effect. So in the past, we've conducted online sweeps, and look, we're going to continue to do this. And it gives us the opportunity to identify lenders whose advertising suggests that a borrower's personal circumstances, for example, it might be a poor credit history, would not be taken into account when they applied for a loan with the lender. And on those occasions, we spoke with the relevant lenders regarding the issues we'd identified in their advertising, and that resulted in them making the changes to their advertising to account for our concerns. Actually, we believe that we can achieve a lot through this type of intervention and engagement in these matters. Other work that we've done around education in the industry includes identifying and engaging with companies and organisations that provide consumer credit, but lending is not their principal or main business, and therefore they're not necessarily aware of their obligations under the CCCF Act. For example, some of these could be lots of local councils, retirement villages, and the likes of charitable trusts. So going forward, the introduction of the certification regime that you'll hear about later will allow us to easily identify new lenders and ensure that they're made aware of their obligations under the CCCF Act. This responds to concerns raised by the credit sector that new lenders may not be aware of the various requirements set out in the legislation when they're starting out. But I would also encourage you as existing lenders, and some of you been in the business for a long time, have a look at your own policies and processes. Don't be complacent and think you have it right. Step back, have a look. If it's not right, get stuck in and get it right before the 1 October law changes. Thank you for your time. I'll now hand back to Louise.
Thanks, John. So I'm now going to briefly speak about what we are seeing in the industry and our priorities. So firstly, high cost. Since the changes last year that introduced new obligations on high cost lenders, which I think you probably all know, in a simplistic explanation are those lenders that offer loans with more than a 50% interest rate, we've had a significant focus on monitoring compliance with these new obligations. There were originally around 30 high-cost lenders in the market, and quite quickly after the introduction of the new laws, these dropped to around 8, and there are around only about 3 lenders now offering high-cost loans in the market. For those that exited the high-cost market, we have monitored and will continue to monitor their fees to ensure that the reduction in interest rate does not lead to the charging of unreasonable fees. We will also continue to have a focus on compliance with the high cost lending obligations for high cost lenders that remain in or later enter the market. Secondly, mobile traders. So given the changes that require mobile traders selling on credit to comply with the Act, it has been important for us to have a real education and monitoring focus on the mobile trader sector. This work is ongoing in our team, and we will continue through into the new financial year. Thirdly, responsible lending. So it won't come as any surprise to you that compliance with the responsible lending principles has been and will continue to be an important focus for the Commission because of the harm that clearly results from lenders not complying with these obligations. Compliance with the new affordability and suitability regulations will also be a priority focus for the Commission, and our education and enforcement approach to these new requirements will be in the context John outlined just before. And lastly, our other priorities. So in terms of other priorities across the ambit of the Act, we are intending on taking a flexible approach that enables us to pivot and be agile into relation to what we are seeing and hearing through the information we collect and are provided across the industry, rather than having fixed and inflexible priority areas. And on this note, data and intel will also be a big focus for us over the coming years. We also have a considerable focus on our certification regime, as well as educating lenders about our expectations in relation to the director and senior manager due diligence duties. I'm now going to pass over to Sonia to lead you into the next part of the seminar. Thanks, Sonia.
Thanks so much, Louise. So now we're going to spend about 10 minutes with each of our experts going through, as Louise said, the 5 main areas of change. They are responsible lending, due diligence, disclosure, fees and advertising, and certification. We've also emailed you a detailed handout for each of these areas. If you didn't receive it, or it's got lost in your inbox, then email us at credit.advocacy@comcom.govt.nz. Penny's just popped it in the chat for you if you want to link through it straight away. And if you email us, we'll send all 5 handouts through to you. I'd like to reiterate this is the first stage in the information about credit law changes. The questions you write up in the survey at the end will inform our webinars, which we're holding for you in a few weeks. Now, I'd like to hand over to Mark Atwell. Mark is a principal advisor in the credit team here at the Commission. And today, he's going to talk to you about the credit reform changes that impact on lenders' responsible lending obligations. Thanks, Mark. Thanks, Mark.
All right. Thanks, Sonia. I'm just having a bit of trouble turning my video on.
It's all good. We can see you now. And thanks everyone for tolerating any technical glitches that happened during the seminar.
Thanks, Sonia. So first of all, as you all know, lenders are currently required to comply with the lender responsibility principles in Section 9C of the CCCFA. So these include an obligation to make reasonable inquiries before entering into a loan so as to be satisfied that it's likely that the loan will meet the borrower's requirements and objectives, i.e. that the loan is suitable. And secondly, that it's likely that the borrower will make the repayments under the loan without suffering substantial hardship, i.e. that the loan's affordable. So from 1 October 2021, lenders will have a few additional obligations when making these inquiries. First, as well as making suitability and affordability inquiries before entering into a loan, lenders will need to make those same inquiries before making a material change to a loan. Secondly, lenders will need to take specific steps set out in regulations in order to satisfy the requirement to make the inquiries needed. And finally, lenders will be required to keep records of the inquiries, including the outcome. So the Responsible Lending Code, as I'm sure you're aware, has also been revised to include additional guidance to support the changes, including the new requirements. And the updated code comes into force from 1 October, except Chapter 12, which relates to how lenders can deal with borrowers where they suffer repayment and other difficulties. And those changes come into force from 1 February. I'll talk a little bit more about that later. So the code is not binding on lenders, but the Act says that evidence of compliance with the code is to be treated as evidence of compliance with the principles. So the first change that I want to talk about coming into effect on 1 October is the requirement to make affordability and suitability inquiry where there's been a material change made to the loan. So material change is going to be will be a defined term, and that covers both increases to a credit limit or where a lender is looking to make further advances they didn't take into account when they last made an assessment.
So Mark, when we think about lenders making inquiries around affordability and suitability, if there is a material change to the loan or credit arrangement, aren't lenders expected to do this already? Isn't this something they're already doing?
Material change is not, at the moment, the principles refer only to making these inquiries where there's been for a new agreement, but as part of being a responsible lender, we would normally expect that lenders would be making these sorts of inquiries anyway where there are material changes. So this law change really just makes the requirement explicit. The second main change I want to talk about coming into effect on 1 October is the requirement to follow the processes set out in regulation when making the suitability and affordability assessments required under the Act. And a failure to follow these or comply with these regulations will be treated as a breach of the relevant responsible lending principle. So in assessing whether a loan is suitable, the regulations provide that the lender will need to gather certain information from the borrower, including asking the borrower questions such as, why do they want the money? How much do they want? How long do they want to have to pay it off? Once lenders have gathered this information, they'll need to assess that and then decide whether or not it's likely that the particular loan they're offering is going to meet the borrower's requirements and objectives. In terms of assessing affordability under the regulations, the regulations prescribe the types of information that lenders need to gather and assess to be comfortable that the borrower's income will exceed their expenses, including the new loan repayment. And I think a change from existing law is lenders can't just rely on what borrowers tell them all the time. So when assessing a borrower's income, you can ask them about this, but you can't just rely on what they tell you. Then the regulations provide that the lenders will need to verify what the lender tells you, what the borrower tells you, based on reliable evidence.
That's complex in many cases. What happens if the lender is unable to obtain reliable evidence?
Well, where it's not practicable to obtain reliable evidence, the lender just needs to assess for themselves whether the income source and the amount of that income is realistic. In terms of assessing expenses, under the regulations, it's a two-part process. So first, lenders need to make an initial estimate of the borrower's expenses by asking the borrower questions or otherwise relying on reliable information, and then assessing the information gathered for omissions. So in practice, this will mean that lenders will need to review a credit report for undisclosed debt. And after the initial estimate is made, the second stage is then to verify the expenses provided by the borrower from reliable evidence. So for example, 3 months worth of bank statements, and then making any necessary adjustments. But the adjustments might include using benchmark expenses if they are higher than the initial estimate, or if you're unable to, if you can't verify the expenses, just estimating what might be a reasonable cost. So the lender, once they've made an assessment of income and expenses, the lenders need to decide if the borrower's income will exceed their expenses in terms of making the final affordability assessment. And in doing so, in order to account for the fact that the lenders may have overstated the borrower's income or understated the expenses, or the borrower may have unexpected expenses, the regulations require that the lender ensure that there's a sufficient or an adequate surplus at the left over, or that the lender has included reasonable buffers in their expense estimates. So obviously what I've given you is just a high-level summary of the regulations, which are very specific. So it's important that you read them and be fully aware of the ins and outs. And the code also contains helpful guidance, including a flow chart, which provides a sort of a visual guide as to how to sort of navigate the regulations. And also, I'd also like to note that it's not the regulations in relation to affordability and suitability don't just apply to loan contracts. They also apply to certain add-on products that are sold with the loan, such as extended warranties, repayment waivers, and credit-related insurance in certain circumstances. And the regulations, as I say, they set out the specific inquiries, particularly around suitability, that lenders need to make in relation to the sale of those products. The third big change relates from 1 October in terms of responsible lending, relates to the requirements to keep records of the inquiries made under the Section 9C. So the records must demonstrate how the lender has satisfied itself as to the decision they've made, including the inquiries they've made and the results of those inquiries and the sort of decision. Lenders need to keep copies of the records for 7 years, and certain people are entitled to ask for those records, including the borrower or the representative, the Commerce Commission, or approved dispute resolution scheme. And if you're asked to provide a copy of these suitability and affordability records, you need to do so within 20 working days. So lastly, I now wanted to touch quickly on the changes to Chapter 12 of the Responsible Lending Code. So as I mentioned earlier, these changes are being brought in a little later than the rest of the code, and they come into effect from 1 February next year.
I know these changes have been underway for some time now. Why are the changes to Chapter 12 of the code coming in later than the other changes?
Well, Chapter 12 deals with the lender's obligations when borrowers encounter repayment difficulties or other problems, and that they're fairly considerable changes compared to the existing code, which is why lenders have been given a few more months to prepare for them. The updated Chapter 12 sets out that lenders should have policies and procedures in place to identify borrowers in difficulty and to sort of proactively manage those repayment difficulties with the borrower. And I think it's clear from the code that in terms of hardship and payment difficulty, the focus isn't just on the statutory unforeseen hardship process. That's just one option for addressing a borrower's difficulty. And the code encourages sort of flexible approach when dealing with borrowers to enable them to access the relief they need or financial mentoring services, and sort of places an emphasis on helping borrowers to make informed decisions about any changes. So finally, I mean, it's important to familiarise yourself with the changes to this chapter, and also, I mean, there's just a general expectation around that lenders will have appropriate policies and procedures for Chapter 12, as well as the other rest of the code and their obligations, and appropriate training in place, and keep those under regular review to ensure your ongoing compliance. Thank you.
Thanks so much, Mark. These are really complex changes, and I look forward to the questions that come through in the survey and then the details that respond to those in the in-depth webinar that will be held in a few weeks. Mark's expertise is absolutely outstanding. I'm really grateful that he made the time to talk to everyone. And now I'd like to introduce Wendy Blennerhassett. Wendy is one of our principal investigators at the Commerce Commission, and she's going to take us through some key changes that relate to due diligence. Hi, Wendy.
Good morning, Sonia.
Wendy, I understand there are some new duties being introduced that will represent a significant change for directors and senior managers with regard to due diligence.
Yes, from 1 October this year, every director and senior manager of a lender will have a personal obligation to exercise due diligence to ensure that the lender complies with its duties and obligations under the CCCF Act. Now, this is a significant change to the law. The duty creates an incentive for directors and senior managers to ensure that a lender has adequate compliance systems and processes in place to meet the Act's requirements. And it encourages senior figures to drive a culture of compliance within a lender from the top down.
That culture of compliance is so important. So who does the duty apply to?
The duty applies to directors or senior managers of lenders. Now, a lender is a person or business that provides credit under a consumer credit contract, and it includes mobile traders if they meet the definition in the Act. A director is someone who has responsibility for managing, directing, or supervising the management of a lender's business and affairs. So it's not just the named directors on the company's office register, although it does include these people, even if they are only sleeping or silent directors. The actual job title or designation doesn't matter. It's the role performed that is crucial. Does the person behave like a director? Do they exercise the powers and functions of a director? And if the lender is a different type of trading entity, say a trust, a partnership, an unincorporated joint venture, then it's going to be anyone with a governance role in that entity comparable to that of a director. So, for example, a partner in a lender partnership is a director for the purposes of the due diligence duty.
It's fascinating to have that clarity that the role someone plays is a vital consideration. So I guess with that in mind, who's considered a senior manager?
Sonia, a senior manager is someone other than a director whose position allows them significant influence over the management or administration of a business. So who is a senior manager? It's going to differ from business to business. It will depend on the size and the structure of the business. It will also depend on the nature of credit the business provides and how responsibilities are allocated. What matters is the actual role the person performs, the amount of influence the person has over the business. So it's not the job title or the way the relationship is structured. Importantly, you can be a senior manager and subject to the duty even if you have no direct responsibility for credit functions and decisions within the business. But the nature of your role will affect what you might reasonably be expected to do. A couple of other things to be aware of, Sonia. If you're named on the Financial Service Providers Register as a director or senior manager, you will be subject to the duty of due diligence while you remain in the role. But just because you're not on the register does not mean that you are not required to comply with the due diligence duty if you're in fact a director or senior manager. And if there are changes within the business and other people assume the role of director or senior manager, then they assume the duty.
Wow, that's fascinating. It's been really interesting to hear you describe in more detail who the duty applies to, especially when it comes to who's named or even not named on the Financial Service Providers Register. Can you tell us more about what the duty means in practice?
Well, it means that as a director or senior manager, you must take reasonable steps to make sure the ways the lender undertakes its lending tasks, its procedures, are designed to ensure compliance with the Act and regulations, and that there is adequate supervision to ensure the procedures are properly implemented and maintained to ensure compliance. So, you must take reasonable steps to make sure the lender does a number of things. These include that the lender establishes and maintains procedures, which may or may not be automated, that are designed to achieve compliance with the Act and the regulations. So this might involve, for example, ensuring that procedures are fit for purpose, that there is reporting on how they are implemented, and that there are enough resources allocated to the procedures. The lender must also require its staff, and that's employees and agents, to follow these procedures. So, for example, are you checking that the procedures are in writing if appropriate, so that they're easily accessible to staff, that staff are trained in how to use them, and that staff are incentivized to follow the procedures, for example, through KPIs. The lender needs to also undertake reasonable checks on whether the procedures do what they're meant to do and that they're being used correctly. And it needs to have methods to identify problems with their effectiveness. So again, for example, are you ensuring that there are mechanisms in place to report issues, that there are regular audits to ensure that the procedures are working and keeping up with changes to the law, and that complaints data is regularly reviewed to identify themes or patterns that indicate issues with the procedures or how they're being implemented. And the leader needs to promptly fix any problems that it finds. So, for example, are you checking how non-compliance is addressed within the business, and that there are procedures in place to identify and compensate affected borrowers? Sonia, this is not an exhaustive list of what might be needed. Other steps might reasonably be required. For example, we suggest making sure that the lender is checking that sales incentives do not encourage non-compliance with the law.
It'd be really good to hear more about that. How can you test if you're doing it right? How's the duty assessed?
It's a good question. Whether you have exercised due diligence will be assessed objectively. The test is whether you have exercised the care, diligence, and skill that a reasonable director or senior manager of a lender of the type and size of your business and with your responsibilities should have exercised. So the care, diligence, and skill required of you as a director or senior manager will vary depending on the circumstances. That is, the size of the business, the type of credit the lender provides, the nature of your responsibilities as a director or senior manager, your position or how influential you are in the parts of the business governed by the Act. In short, the greater the influence you have, the greater the care, diligence, and skill that is going to be expected of you. Just some points about the extent of the duty that I want to cover. First, you cannot avoid your responsibility to exercise due diligence by expecting someone else will do it. It is not enough for you to assume or trust that another person in the business is taking care of compliance. Second, you do not necessarily breach your duty just because the lender breaches the Act. The important thing is that you have taken reasonable steps to ensure compliance. Third, we are suggesting that you keep records of what you have done to meet your duty. And finally, your liability for a breach of the due diligence duty does not disappear or refresh after you leave the business. You can still face consequences for failing to meet your duty while you were a director or senior manager.
So You can't assume it's covered just because someone else is doing it. And you have to take reasonable steps to ensure compliance. And your duty doesn't disappear if you leave the business.
That's right.
I'm sure lenders will be interested to know what happens if they do breach the due diligence duty.
Well, there are personal consequences, Sonia, and the liability can be substantial. If you breach your due diligence duty, the court can order you pay a pecuniary penalty of up to $200,000. Now, importantly, a lender can't indemnify you against this penalty, and nor can it indemnify you for any costs incurred in defending the legal proceedings in which the penalty was imposed. And you can't obtain insurance to cover any penalties or defence costs incurred either. Any contracts that claim to offer this protection are void. Also, if the court finds that the lender has breached the duty and you have breached the duty, and borrowers are entitled to recover statutory damages, compensation, or exemplary damages, you may be liable for them too.
So then, is there anything that directors or senior managers should be doing right now?
Well, to start, if you're a senior manager or a director of a lender, then you need to take steps to understand the lender's obligations under the Act and the regulations. So things like the lender responsibility principles, obligations around disclosure, the charging of interest and fees, obligations related to cancellation, hardship, and certification. Second, if you have any questions about what you are required to do to comply with the Act, we recommend you obtain independent advice. You can rely on information from subject matter experts, such as legal advisors, if it is reasonable to do so. However, in order to meet the duty of due diligence, you should have enough knowledge about the nature of the credit being provided, the lending tasks, and the lender's obligations under the Act to know enough to ask the right questions and challenge information provided by any subject matter expert. And finally, if you haven't already done so, get a copy of the Commerce Commission's guidance on the new due diligence duties and get familiar with it. The guidance is available on the Commission's website and it includes a lot of additional helpful information and examples, Sonia.
That's great, Wendy. Thank you so much. I think that gives lenders a good overview, and it's great to know that there's guidance on the website to give more details. I'm sure people will have more questions, which of course they can submit through the survey at the end of this session for Wendy and all of us at the Commerce Commission to pick up in the in-depth sessions that we'll be holding in a few weeks. Thanks so much, Wendy.
Thanks, Sonia.
Now I'm thrilled to introduce our Chief Legal Counsel for Credit, Crystal Uden, who's going to share with us her insights around disclosure. Hi, Crystal.
Hi, Sonia. Thanks for that intro. As Sonia mentioned, I'm Chief Legal Counsel of Credit at the Commission. This is my 6th year at the Commission, and I've been working exclusively in consumer credit in that whole time. So I live and breathe credit. It's my pleasure to talk to you today about the upcoming disclosure changes. Disclosure may not be the most exciting subject, so please don't turn off your Zoom anytime soon, because there are real consequences if lenders don't get disclosure right. It's therefore important that you get your disclosure house in order.
Hey, so Crystal, before you get started on what's changing, could you remind everyone what the current disclosure obligations are?
Sure. So currently we have 4 types of disclosure. They are initial disclosure. That's the disclosure of all the information in Schedule 1 of the CCCFA that's relevant to the loan. The second one is continuing disclosure. That's generally provided every 6 months during the life of the loan. There is variation disclosure, which must be provided when the loan is varied. And lastly, there's request disclosure, which applies when the borrower or their representative asks for copies of certain documents. And Sonia, I think it might be time for a question for you. Can you remember from yesterday how many new areas of disclosure are coming?
So there's 4 existing.
Yep.
And I'm going to say 3 new ones.
That's right. So I'm actually going to talk about 5 things, but of those 5, there are 3 new types of disclosure that lenders should get ready for. The first is financial mentoring disclosure. Then we have dispute resolution service disclosure, and finally debt collection disclosure. There are also 2 other things that I'm going to talk to you about. The first is some rules coming in about extra disclosure and I'll explain why I've disclosed it, if you're advertising in another language, and also some clarity around what has to be disclosed when you vary a contract. Now, there are 5 things I'm going to talk about, so don't worry if you don't know about those yet. That's exactly what I'm here for. And don't feel that you need to take notes or furiously scribble away what I'm saying. We've recently released some updated disclosure guidelines. As Mark and Wendy mentioned, our disclosure guidelines and all our other guidelines are available on our website. And if you're a member of our mailing list, you would have also been emailed a copy of the disclosure guidelines straight to your inbox. Pretty much everything I'm going to mention is set out in more detail in our guidelines. So feel free to just listen up and then go away and have a read of those. I'll go to the 3 new areas of disclosure soon, but I'll get out the 2 sort of odd man out first. The first one is the real odd man out. It's the one that I said wasn't technically disclosure. Disclosure as we know it is prescribed information that must be disclosed at certain points during the contract. So for example, before the contract is entered into, we all know that lenders must provide initial disclosure. When the contract is varied, lenders must provide variation disclosure. If the lenders want to repossess something, they have to provide disclosure on that, etc. What you have to disclose and what information you have to provide for each of those points is very prescribed. So for example, we know Schedule 1 has a list of important information that must be disclosed. And we know that in those circumstances where the information is prescribed, the consequences of not disclosing it can be very high. So for example, if you don't provide proper initial or variation disclosure, then Section 99(1)(a) kicks in. And Section 99(1)(a) provides that for the period of non-disclosure of the information that you should have disclosed, you're not able to enforce the contract and recover your fees and interest. This new requirement is a little bit different. This one says, if you advertise in a language different from the one that you're using in your loan agreement, and your advert is less than 6 months old, then you may need to offer information about your loan in the advert language. So the key here is you're looking for information that will enable your borrower to make an informed decision. Here, there's no prescription on what information you must provide. It is information about your loan that would be helpful for the borrower to make their decision. So what you disclose is at your discretion. Now, the Commerce Commission is never going to say you gave too much information to your borrower in the advertised language. But we would give a little bit of a warning here to make sure that what you are providing, the translated version you're providing, is exactly the same as what's in your loan agreement. The reason for that is, as we know with the Treaty of Waitangi, there are 2 versions, and an issue happened with the translation from Māori into English, and that is that they don't actually marry up. So if, for example, you're advertising in Samoan, but your loan agreement is in English, and you provide 2 copies of your loan agreement, one in English and one in Samoan, but they don't actually match, then the version that is most beneficial to your borrower is the version that will apply. So just be careful if you're translating everything, that your translations are perfect. The Revised Responsible Lending Code also recommends that where you suspect your borrower doesn't have a good understanding of the language you're using in your documentation, that you have processes in place to pick that up and then to offer them that information in various points along the way of your contract. So how you could do that, for example, is if you're an online lender, you could have a tick box exercise for your borrowers that says, you know, English may be their second language, or I speak another language. What might be a language that's helpful for you to receive further information about this loan? If you have staff that interact with your borrowers on a one-on-one basis, you could be training them to pick up where, say, English might be a second language for your borrower, or where providing information in another language might be helpful to your borrower. Everything I just mentioned about borrowers and loan agreements applies equally in respect of guarantees and guarantors.
So then what are the consequences if you fail to provide that information in other languages?
This one is a pecuniary penalty, and it's up to $600,000. So it is important that lenders have processes in place to pick up when their borrower might need some additional information in another language, especially around that advertising point if the advert was less than 6 months old. So I've addressed the disclosure. point. And the second thing I wanted to talk to you about is clarity around variation disclosure. The current variation disclosure requirements are set out in section 22. They are that in the event of an agreed variation between the borrower and lender, the lender must provide disclosure of the full particulars of the change and anything prescribed in the regulations. Now, to date, full particulars of the change was not defined, and there hasn't been anything in the regulations. That's changing from 1 October. From 1 October, it's still full particulars of the change, but now we have some regulations too. Turning to full particulars of the change, the Commission's position has been and remains that full particulars of the change means any agreed change that would alter a piece of the information in Schedule 1. The regulations now also provide that if the variation affects 5 matters, then the effect of that variation must be disclosed. The easiest way to remember the 5 matters that it impacts is that it's all to do with money. So if the variation affects the credit limit, the annual interest rate, the credit fees and charges, the total interest charges, and the payments required, which could be number of payments or the amount of payments, then you must disclose that. Now, all of those 5 pieces of information are already found in Schedule 1. So if you've been providing variation disclosure in line with what we consider full particulars of the change means, which is anything that affects the Schedule 1 information, then your processes are probably in order and you're probably fine on that, but you should go and check. I mentioned earlier about our revised disclosure guidelines. Happy to report that in that guideline, we have put in something that we hope will be helpful to lenders. It's an example of what we think might be best practice for providing variation disclosure. In that example, you'll see that we suggest that lenders might want to look at providing the current information that applies side by side with the information that will apply once the loan is varied. So for example, if the payment amount was $100 and now it's $80, you would provide that information side by side so that your borrower could make an informed decision before properly agreeing to the variation. Sonia, I think you want to ask me about the consequences for failing to provide the proper variation disclosure, because yesterday I think you're a little bit concerned that it might be quite a high one. And that's true. Yesterday I mentioned that the consequences for failing to properly disclose variation disclosure is actually even higher than the pecuniary penalty I mentioned earlier. For this one, as we know, Section 99(1)(a) is a consequence of failing to provide proper initial or variation disclosure. So if you fail to provide that variation disclosure properly, Section 99(1)(a) will kick in. And in addition to that, if you don't get it right, it is an offence and can lead to a fine of up to $600,000. The third and fourth thing I'm going to talk to you about are quite similar. These are the first 2 sets of new disclosure that I mentioned earlier. They're similar, so I'll talk about them at the same time. They are financial mentoring disclosure and dispute resolution disclosure. They both carry the same consequence. Failure to disclose the information required is an offence and can lead to fines of up to $600,000. They both apply from 1 October. For financial mentoring disclosure, if your borrower defaults, makes a hardship application, and/or you decline a high-cost loan application, then from 1 October, you must disclose information about financial mentoring services. Happily, the regulations set out specifically what you must disclose about those services and includes information like that the mentoring service is free. The new Responsible Lending Code comes in on 1 October, and Mark mentioned earlier before that Chapter 12 of that code comes in from 1 February. You'll see that Chapter 12 has a recommendation around disclosure of financial mentoring services. That recommendation is that lenders include information about the financial mentoring services when sending their payment reminders. For dispute resolution service disclosure, from 1 October, if your borrower makes a hardship application, complains about any enforcement action you've undertaken, or makes any other complaint covered by the regulations, then you must disclose information about your dispute resolution scheme. Makes any other complaint covered by the regulations is pretty broad. It's essentially if your borrower made a complaint and your response to that complaint is, XYZ, here's my response. Your next step, if you're not happy with that response, is to go to my dispute resolution scheme. Then you must tell them about your dispute resolution scheme. Again, helpfully, the regulations have set out specifically what you must disclose. It's generally the common sense information like the name of your financial dispute resolution scheme provider, it's quite a mouthful, the contact details for them, that your service is free, etc. But again, go and have a look at the regulations because it's set out specifically. The third and final new disclosure that I said I'd mention, and the last thing I'm going to talk to you about, is debt collection disclosure. So from 1 October, before any debt collection starts, you must disclose certain information. There are some exceptions to that. Firstly, payment reminders aren't counted as debt collection. And if the goods are at risk, then you don't need to provide the disclosure before you go ahead with repossessing those goods, for example, which makes sense because if you had to tell them about it beforehand, then your goods are at even more risk. Again, here, the regulations have set out specifically what you have to disclose. And for this one, failure to disclose is an infringement offence, and you could be fined up to $30,000. So in totality, there are 4 disclosure areas already, 3 new ones are coming, and there's some clarification around variation disclosure, and you need to get your documents in order if you're going to be advertising in another language. I think a key takeaway from all of this is you'll need to pay close attention, obviously, to the CCCFA, but also to the regulations. In my view, the regulations are playing a bigger role than they have before. They're very prescriptive and they'll need to be followed. So definitely make sure you get yourself a copy and go through all the things that you need to comply with.
That's fantastic, Crystal, and really good advice. Thank you. So you can find those regulations and codes and guidance by entering Responsible Lending NZ into your favourite search engine. Thanks so much, Crystal.
You're welcome. Thank you.
And if you were searching for those using your favourite search engine, you might see a little ad pop up beside you, which is a nice segue into James McIver's session on the changes to fees in advertising. Welcome, James. So James is one of our principal investigators, and he's going to talk about 2 things: the rule changes that affect advertising and the setting of fees.
Nice segue, Sonia, by the way. Yes, that's right. So the rules that I'll be talking about are those that come into effect 1 October that relate to advertising and the setting of your fees. So look, in most cases, the changes reflect what we consider to be good practice under the current law and hopefully simply reinforce what you're already doing. Importantly, both these topics relate to the due diligence obligations that you will have heard about from Wendy earlier. Directors and senior managers have a general obligation there to take reasonable steps to ensure that the appropriate policies and procedures are in place for compliance with the law. So advertising. The CCCFA has a number of responsible lending principles, of course, found in section 9C, which you must comply with as part of being a responsible lender. And one of those considers advertising.
So what types of advertising are covered under the new regulations?
Yeah, the definition is actually pretty broad, and it covers all sorts of ways to communicate with prospective borrowers. Now, the rules cover not only your own advertising as a lender, but any advertising that you have instigated or authorised. So as part of your obligation to help a borrower reach an informed decision, your advertising cannot be misleading, deceptive, and confusing. And any advertisements must apply with advertising standards set out in the new regulations. These are found in the succinctly titled Credit, Contracts and Consumer Finance Amendment Regulations 2020. And I should note that there is also a useful section on advertising in the Responsible Lending Code, which was, of course, refreshed earlier this year. The regulations, although new, really, just as I said before, really reflect what we think to be good practice under the current law, but they do set out some really helpful do's and don'ts to assist you.
That helpful code again. So, James, what are some of the do's?
Yeah, so look, if you advertise a payment amount, really important that you also advertise the total payments that will be payable if they can be worked out for the under the contract. And if they can't be worked out, you'll need to state the annual interest rate that will apply under the loan. If you advertise an interest rate, It must be the annual interest rate, so no flat interest rates, please, or the range of rates, I should say, that would be applicable to the borrower. And you must also state if the annual interest rate is fixed for all or part of the term, or not fixed at all, so a floating rate. And also include whether mandatory fees, when any fees apply, and any of those that are mandatory credit fees as well, such as establishment fees. Lastly, if you're referencing the speed of your approvals, you must include a statement that this is subject to responsible lending inquiries and checks. So all of this information must be in a plain language that is clear, concise, and intelligible. You should take into account your intended audience and also the nature of your advertisement too. So a billboard on the motorway, for example, with a lot of fine print is unlikely to pass that test. Also with this, bear in mind that if you advertise in a different language, you'll remember from Crystal's presentation that you'll also need to make sure that information's available about your loans in that language.
And what about the things to avoid?
Yeah, look, you cannot say or even imply that you will not inquire into or take into account the borrower's circumstances when considering a loan. And you cannot advertise that a loan has already been approved if inquiries into the borrower's circumstances haven't been carried out. So as a reminder, there are new rules governing advertising, which come into force from October this year. These rules found in the new regulations give the clear do's and don'ts for your advertising, which you should make sure are built into your compliance processes.
Thanks, James. It's great to get your insights into the advertising changes. So now, what do lenders need to know when it comes to fees?
So any credit or default fee you charge cannot be unreasonable. That's the basis of the Section 40 area fees provisions, and any fees that should be set at an amount, which will recover your costs or losses incurred in relation to that fee. Important to get that right. So on that basis, they should not include any amount of profit. Now that's existing law, so no surprises there. But from October, you're required to keep records about how you have calculated those fees. And these records must demonstrate that each fee is not unreasonable at the time that you set that fee. They must be kept for 7 years and also provided to the Commission should we request them. Now, it's also good to note here that dispute resolution services also have that same ability to request those fees calculations. Now, we appreciate that setting your fees can be a really technical area, and getting it wrong also can be very costly. So to understand what you can recover and what you cannot, we have a precedent case, the Sports Zone MTF case, that provides us with a lot of our understanding as to how to apply those fees provisions. The Commission has taken the important parts of that 10-year case and squeezed them into the credit fees guidelines, which are available on our website. They've been around for a while now, and we're currently working through updating them. So we're hoping to have something out ready by October, so watch this space. Now, in preparing to talk to you about fees, I have been thinking through what I would expect to see in your fees calculations. So I'll offer this as a guide only and not something that you necessarily need to stick to, because I appreciate that there are many different ways to do this, of course. So the model that I'll be talking about determines the fee by calculating the relevant costs or losses and dividing by the estimated number of fees that you will charge. Now, in thinking about your relevant costs or losses, consider for yourself whether they are closely related to the activities giving rise to the fee. Really important, that point. So for a start, identify all the categories of costs that are relevant to each fee. There might be, you might consider things like staff costs, direct costs, say credit check costs, phone costs, maybe part of your overheads there. And then from there, consider how much of each of that cost category can be recovered through the fee. Now, of course, recording how you've come to this conclusion will be really, really important. So for example, let's think about a staff member, that individual staff member of yours. Their time might be split across a number of activities, for example, establishing a loan or following up on defaulting borrowers. So after determining that it would be appropriate to recover the staff member's time and the costs associated with that, at a category level, then you'll need to determine how much of that staff member's time to allocate to each fee, in this case, the establishment fee and the default fee. Now, you'll need to remember also that not all of the cost category can necessarily be recovered. In the case of the staff member, when working on establishing loans, you'll not be able to recover the costs associated with loans which do not go ahead or are declined. And in the case of the phone system, you cannot recover the costs associated with the general running of the business. So once you've done this, you'll have the total of relevant, closely related costs, which can then be divided by the estimated number of customers that you will be charging the fee to. Now, this estimate will necessarily be worked out on a forward-looking basis and likely taking into account past performance and also your future expectations. Again, record how you have determined the estimates of how much of each fee you will charge, how many, sorry, of each fee you will charge. And with that, you have your fees. The last consideration with this is review, really, really important. The fees calculations are not set and forget and will need to be reviewed as inputs change over time. If your costs change or the estimated number of fees that you expect to charge changes, you'll need to review your calculations and change your fees if needed. When thinking about when to review, consider both internal and external factors. The change in your costs, internal, I would say is easier for you to monitor or predict, but I would suspect that the estimates of how many fees you will charge will be more tricky. The impact of a fast-growing business or the change in demand, such as we're probably experiencing now with COVID, have the potential to get you off track very, very quickly. So in summary, from 1 October, you are required to keep records about how you set your credit and default fees, and these can be requested by the Commission, and you need to keep them for 7 years. So when setting your fees, consider the relevant cost category, how much of that cost category can be recovered, and remember to review your fees should things change.
Thanks, James. That was a really good summary. The fees and advertising handout has lots of detailed information. If you miss these, just send us an email and we'll give them to you. And of course, they'll also be available on our website soon. Thanks so much, James. And our final expert for today is Kylie Higgs, and she's going to share with us information about certification. Hi, Kylie.
Hi, Sonia. Thank you for the introduction. Just to build on that introduction, my role at the Commission is to manage the certification services team. This is a new team that's been set up to manage and support the new certification requirement. Myself and my team have formulated some key points, and we hope that these will help you navigate the new certification requirements. These points have been designed not only from our own learnings, but also from feedback from the credit industry.
It's not a small piece of work either, and I know there's lots of interest in this area. Would you like to tell us a little bit about the new certification requirement for lenders?
Certainly. So from the 1st of October 2021, unless you're exempt, lenders and mobile traders are required to be certified by the Commission if you wish to provide these services to consumers. Currently, you're exempt if you're already licensed or authorised by the Financial Market Authority or by the Reserve Bank. Now, this certification generally is for a 5-year period. There's a couple of reasons why this new initiative has come into play. Firstly, it's to raise the standard for lenders and mobile traders operating within the credit industry. And secondly, it will help provide better protection for the consumers. Now, to gain certification, all individuals, if you're a sole trader, or all directors and senior managers of entities, need to be assessed as being fit and proper persons to hold their positions. You can apply for certification through the Maintain Financial Services tab on your FSPR dashboard. When you select either the Consumer Credit Contract or Mobile Trader Service, you'll then be emailed automatically from the FSPR with instructions on how to pay the required fee. And this will also include your application forms that you need to complete. The fee is $1,055, that's excluding GST, and that's for each individual or each director or senior manager included on the application. This is payable on the FSPR and lasts for that 5-year certification period. This is a cost recovered fee, and it has been set by the Ministry of Business, Innovation and Employment, and they are looking to review that in the next 3 years. In assessing whether an individual is a fit and proper person to hold their position, the Commission will consider assessment criteria which looks at probity, reputation, financial integrity, and competency and capability. The information provided for the assessment is reviewed from a holistic point of view, and no one single criteria will determine the outcome of the application. Now, the outcomes available after the assessment, we can either certify, we can certify with imposed conditions on the certification, or you can request conditions yourself, or we can not certify. If we intend to refuse to certify, then you will have an opportunity to make a submission to us before a final decision is made, and you can appeal the decision to refuse to certify or to certify with conditions to the District Court. Now, there are penalties if you breach the certification requirements, and the court may order payment of penalties if you provide consumer credit without being certified, if you represent that you're certified when you are not, or if you don't notify the Commission of changes in your circumstances within 10 working days of knowing about these changes, or if you provide false or misleading information on your application form.
Okay, that's really important to know. So when do lenders need to be certified?
That's a great question. So albeit certification does become compulsory from the 1st of October 2021, and after this date, lenders and mobile traders will need to be both certified by the Commission and registered on the financial service provider to provide consumer lending services. But timing does differ depending on your annual confirmation month. And this is in order to manage the number of applications that we expect to receive. So we've aligned your certification due date with the end date of your annual confirmation month. So for an example of this, if you have an annual confirmation month of April, then you have a certification due date of April the 30th. Now that means you will need to be certified by April 30th, 2022, because that is your first annual confirmation after the 1st of October. Another example, if you have a November filing month, then you have a certification due date of November 30th, and that means you need to be certified by November 30th, 2021, because that will be your first annual confirmation filing after the 1st of October. Now, as a form of protection for you, if you do apply for certification more than 2 months prior to your certification due date, then you can legally continue to offer lending and mobile trading services if we have not yet made a decision by that date. So in regards to the April example, it would be the 1st of March, and for the November, you'd need to get your application in by October 1st.
It's a tricky calculation to make on the fly, but if I've understood you correctly, it's all aligned to your annual confirmation month with a line in the sand that you have to factor in around October 1.
That's correct.
So once lenders are certified, what are their obligations?
Now, you do have an obligation once certified to remain a fit and proper person to hold your position, and any material changes that could affect your certification will need to be communicated to the Commission within 10 working days. This will allow us to reassess your certification. If the material changes involve the addition of a new director or senior manager, then they will need to be assessed and pay the fee. Now, there are some things that you can help us with so that we can efficiently put through your assessment. We ask that you please ensure all information on the FSPR is up to date, including contact details. Now, if you've made any changes to your directors on the company register, please make sure you've refreshed the information from the company's register through to the FSPR so that we're working with the most up-to-date information. It's important also that you list all your senior managers. Now, this can be difficult to determine who is the senior manager. However, our guidance has thorough definitions for you. When you wish to trigger certification, you need to select consumer credit contract or mobile trader. If you don't wish to trigger certification and wait until your confirmation next year, then you need to select consumer credit contract prior to certification. And this means that certification is not triggered at this time. Please also ensure that you provide complete and accurate information in your application form. So this is critical for our ability to assess efficiently.
That's great, Kylie. Thank you. And thanks to you and your team for all the work you've done establishing this. I know it's been lots of hard work.
Well, we hope this information is helpful around certification. I'd just like to say there is guidance on the website and a sample of our application form on the website as well if required.
That's super helpful. Thanks, Kylie. And thanks to all of you for watching this webinar. And I saw a question pop up before about it being recorded. Yes, we are recording it so that people can reference it again. And we'll make that available on our website, and we'll include a link to that when we send out some information about the in-depth webinars. So again, thanks for taking the time in these unusual days to join us and watch our presentation online. We know it's not as good as being at a seminar in person, so we're really grateful that you've taken the time out of your day to join us. I thought I'd do a quick summary, and apologies if you can hear background noise. There's guidance on the website and there's more coming, so keep checking and make sure that your details are up to date, because we do email you when new guidance is published. The handouts, which were emailed as part of that, are a useful summary. And if you didn't get them, please email us at credit.advocacy@comcom.govt.nz. So in a few weeks, there's 5 sessions, one on each of the key subjects, and these are 45 minutes long. And importantly, they'll be created based on your questions. So please, when you close this window, it will invite you to head to a survey where you can pop questions you'd like answered or tell us about what information you'd like covered. So when the window comes up, click continue to go to the survey. Penny has also just popped a link to the survey in the chat if you'd like to go to that right now. So thank you. It allows us to make sure that the next sessions, our in-depth webinars, provide you with what you need to know. So in the next few days, you'll receive an email from us with a link to attend the in-depth seminars. And as I said, there's one in each of the 5 areas. You can choose to attend all of them, some of them, one or none. It's up to you. So before we close, I know Louise would like to say thank you personally. So I'll step aside for our General Manager.
Thank you, Sonia. And I think you carried on very admirably there while either your son or husband were in the background busy doing some housework. I think all of you online will know what that's like as well. And look, I wanted to say thank you to the team and also especially all of you on the call who have made the time to attend today. As I mentioned at the beginning of the seminar, and as Sonia has also mentioned, we do appreciate how challenging it can be attending an online seminar while we are all in level 4. And we also recognise that online seminars themselves are a little harder to engage in than in-person presentations. But we really wanted to press on with our educational program on the reforms despite the current COVID situation. I also wanted to finish off by letting you know about the education program we have coming up in early October for the consumer advisory sector, being budget advisors and financial mentors. We know how important it is for both lenders and borrowers that borrowers and those that help them are aware of the changes to expect after 1 October in relation to how lenders engage with them and what will be different to before. We know you will also be thinking about how you do that with your own borrowers. So the engagement program we have will be very similar to what we are doing for yourselves as lenders and will be in 2 parts, but of course messaged in the right way for the advisory sector to help them to help those borrowers that they work with. So finally, again, thanks for giving up your time to attend. And I'll now hand back to Sonia to close off the seminar with a karakia.
Thank you. I will close as we opened, and I do apologise. My neighbour is mowing his lawn. So I'll close with karakia. Unuhia, unuhia, unuhia ki te uru tapanui. Ke wātia, ke mana te nāko, te tiana te wairoa e te ara tangata, koe rā e rongo, whakaerea ke runga, kia tina huie, tai kie. Thank you very much, everyone, and thanks for joining us.